Okay, I'm going to read Markman versus Westview Instruments, Inc. Heard by the Supreme Court, Justice Souter delivers the opinion in court in its 1996. The question here is whether the interpretation of a so-called patent claim, the portion of the patent document that defines the scope of the patentee's rights, is a matter of law reserved entirely for the court or subject to the 17th Amendment guarantee that a jury will determine the meaning of any disputed term of art about which expert testimony is offered. We hold that the construction of a patent, including terms of art within its claim, is exclusively within the province of the court. So that's the issue in the holding, in a nutshell. Part 1, it has long been understood that a patent must describe the exact scope of an invention and its manufacturer to secure to the patentee all to which he is entitled and to apprise the public of what is still open to them. Under the modern American system, these objectives are served by two distinct elements of a patent document. First, it contains a specification describing the invention in such full, clear, concise, and exact terms as to enable any person skilled in the art to make and use the same. Second, a patent includes one or more claims which particularly point out the distinctly claim the subject matter which the applicant regards as his invention. Invention. Good boy. Okay, and that's from Title 35 of the United States Code, Section 112. A claim covers and secures a process, a machine, a manufacturer, a composition of matter, or a design, but never the function or result of either, nor the scientific explanation of their operation. The claim defines the scope of a patent grant and functions to forbid not only exact copies of an invention but products that go to the heart of the invention but avoids the literal language of the claim by making a non-critical change. In this opinion, the word claim is used only in the sense peculiar to patent law. Characteristically, patent lawsuits charge what is known as infringement and rest on allegations that the defendant without authority made, used, or sold the patented invention within the United States during the term of the patent, therefore. Same title, Section 271A. Victory in an infringement suit requires a finding that the patent claim covers the alleged infringer's product or process, which in turn necessitates a determination of what the words in the claim mean. Petitioner in this infringement suit, Markman, owns United States reissue patent number 33,054 for his inventory control and reporting system for dry cleaning stores. The patent describes a system that can monitor and report the status, location, and movement of clothing in a dry cleaning establishment. Markman's system consists of a keyboard and data processor to generate written records for each transaction, including a barcode readable by optical detectors operated by employees who log the progress of clothing through the dry clean process. Respondent Westview's product also includes a keyboard and processor, and it lists charges for dry cleaning services on barcoded tickets that can be read by portable optical detectors. Markman brought an infringement suit against Westview and Althon Enterprises, an operator of dry cleaning establishments using Westview's products, collectively Westview. Westview responded that Markman's patent is not infringed by its system because the latter functions merely to record an inventory of receivables by tracking invoices and transaction totals rather than to record and track an inventory of articles of clothing. Part of the dispute hinged upon the meaning of word inventory, a term found in Markman's independent claim 1, which states that Markman's product can maintain an inventory total and detect and localize spurious additions to inventory. The case was tried before a jury which heard, among others, a witness produced by Markman who testified about the meaning of the claim language. After the jury compared the patent to Westview's device, it found an infringement of Markman's independent claim 1 and dependent claim 10. What did it find? An infringement. Court nevertheless granted Westview's deferred motion for judgment as a matter of law, one of its reasons being the term inventory in Markman's patent encompasses both cash inventory and the actual physical inventory of articles of clothing. Under the trial court's construction of the patent, the production, sale, or use of tracking system for dry cleaners would not infringe Markman's patent unless the product was capable of tracking articles of clothing throughout the cleaning process and generating reports about their status and location. Since Westview's system cannot do these things, the district court directed a verdict. Markman appealed, arguing it was error for a district court to substitute its construction of the disputed term inventory for the construction of the jury had presumably given it. In the United States Courts of Appeals for the Federal Circuit affirmed, holding the interpretation of the claim terms to be the exclusive province of the court and the Seventh Amendment to be consistent with that conclusion. Markman sought our review on each point, and we granted certiorari. We now affirm. The Seventh Amendment provides that in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Since Justice Story's day, we have understood that the right of trial by jury thus preserved is the right which existed under the English common law when the amendment was adopted. In keeping with our long-standing adherence to this historical test, we ask first whether we are dealing with a cause of action that either was tried at law at the time of the founding or is at least analogous to one that was. That language probably comes from Toll v. United States in 1987. If the action in question belongs in the law category, we then ask whether the particular trial decision must fall into the jury in order to preserve the substance of the common law right as it existed in 1791. As to the first issue, so this is all part of the analysis, is the historical part. As to the first issue, going to the character of the cause of action, the form of our analysis is similar. First, we compare the statutory action to 18th century actions brought in the courts of England prior to the merger of the courts of law and equity. And that citation comes from Grand Financiera S.A. v. Nordberg in 1989, so citation omitted. Equally familiar is the descent of today's patent infringement action from the infringement actions tried at law in the 18th century, and there is no dispute that infringement cases today must be tried to a jury as their predecessors were more than 2 centuries ago. So that's the historical analysis. Is that 2 centuries ago, patent infringement went to a jury trial, and therefore treated that way today. Except the second prong of the analysis we're going to look at is more important than the first prong, the historical prong. Part B. This conclusion raises the second question, whether a particular issue occurring within a jury trial, here the construction of a patent claim, is itself necessarily a jury issue. The guarantee being essential to preserve the right of the jury's resolution of the ultimate dispute. In some instances, if you remember, actually the issue here is that the judge set aside the jury's judgment. Here the construction of a patent claim was what that was regarding, is itself necessarily a jury issue. The guarantee being essentially to preserve the right to a jury's resolution of the ultimate dispute. In some instances, the answer to this question may be easy because of clear historical evidence that the very subsidiary question was so regarded under the English practice of leaving the issue for a jury. But when, as here, the old practice provides no clear answer, we are forced to make a judgment about the scope of the 17th Amendment guarantee without the benefit of any foolproof test. The court has repeatedly said that the answer to the second question must depend on whether the jury must shoulder this responsibility as necessary to preserve the substance of the common law right of trial by jury. Toll v. United States, Supra at 426, emphasis added, quoting Colgrove v. Batten of 1973. Quote, only those incidents which are regarded as fundamental, as inherent in and of the essence of the system of trial by jury are placed beyond the reach of the legislature. So basically Tull is citing Colgrove. The substance of the common law right is, however, a pretty blunt instrument for drawing distinctions. We have tried to sharpen it, to be sure, by reference to the distinction between substance and procedure. We have also spoken of the line as one between issues of law and fact and law. But the sounder course, when available, is to classify a mongrel practice like construing a term of art following receipt of evidence by using the historical method, much as we do in characterizing the suits and actions within which they arise. Where there is no exact antecedent, the best hope lies in comparing the modern practice to earlier ones whose allocation to court or jury we do know, seeking the best analogy we can draw between the old and new. There's a note to the side, like a footnote, which is not the judge's opinion, it's the author of the case book. Note the court's language here, pretty blunt instrument, we have tried the best hope in seeking the best analogy we can. Such language does not inspire much confidence in its analysis. Should something so important as the jury right be based on such a seemingly imprecise approach? Part C of this opinion. Prior to 1790, nothing in the nature of a claim had appeared either in British patent practice or in that of the American states, and we have accordingly found no direct antecedent of modern claim construction in the historical sources. Practice did not achieve statutory recognition until the passage of the Act on July 4th of 1836. An inclusion of a claim did not become a statutory requirement until 1870. The closest 18th century analog of modern claim construction seems then to have been the construction of specifications, and as to that function, the mere smattering of patent cases that we have from this period shows no established jury practice sufficient to support an argument by analogy that today's construction of a claim should be a guaranteed jury issue. So there's really no basis in history on the issue. And the issue is like whether the jury's judgment can be set aside by the judge or supplanted by the judge on that particular question, which I think has to do with interpreting the language of the claim. The word inventory particularly. Part 3 of this opinion. Since evidence of common law practice at the time of the framing of the Constitution does not entail application of the 17th Amendment's jury guarantee to the construction of the claim document, we must look elsewhere to characterize its determination or meaning in order to allocate it as between court or jury. We accordingly consult existing precedent and consider both the relative interpretive skills of judges and juries and the statutory policies that ought to be furthered by the allocation. So this is the analysis that the court is going to follow, and it considers precedent first and foremost, and then it looks at the interpretive skills of judges and juries, and third, the statutory policies that ought to be furthered by the allocation. So, Part A under Part 3 is the two elements of a simple patent case: construing the patent and determining whether infringement occurred were characterized by the former patent practitioner, Justice Curtis. The first is a question of law to be determined by the court construing the letters patent and the description of the invention and specification of claim annexed to them. The second question of fact is to be submitted to a jury. And this, I guess, is going to be precedent. So I call this analysis sub 1 regarding the precedent. In arguing for a different allocation of responsibility for the first question, Markman relies primarily on two cases: Bischoff v. Weathered and Tucker v. Spalding. These are said to show that evidence of the meaning of patent terms was offered to 19th century juries, and thus to imply that the meaning of a documentary term was a jury issue whenever it was subject to evidentiary proof. That is not what Markman's cases show, however. Neither Bischoff nor Tucker indicate that juries resolve the meaning of terms of art in construing a patent, and neither case undercuts Justice Curtis's authority. So, in terms of the counter-argument to what they found in their precedent analysis, this is not persuasive. So that's kind of like their holding on analysis sub 1, looking at the precedent. So Part B of Part 3, where history and precedent provide no clear answers, functional considerations also play their part in the choice between judge and jury to define terms of art. We said in Miller v. Fenton, and when an issue falls somewhere between a pristine legal standard and a simple historical fact, the fact-law distinction at times is turned on a determination that as a matter of the sound administration of justice, one judicial actor is better positioned than another to decide the issue in question. So it turns out here for judges, not juries, are better suited to find the acquired meaning of patent terms. So this is the second prong, which has to do with the skills. So part of the analysis, sub 2 on the question of skills between the judge and the jury. The construction of written instruments is one of those things that judges often do and are likely to do better than jurors unburdened by training in exegesis. Patent construction in particular is a special occupation requiring, like all others, special training and practice. The judge, from his training and discipline, is more likely to give the proper interpretation of such instruments than the jury, and he is therefore more likely to be right in performing such a duty than a jury can be expected to be. Such was the understanding nearly a century and a half ago, and there is no reason to weigh the respective strengths of judge and jury differently in relation to the modern claim. Quite the contrary, the claims of patents have become highly technical in many respects as the result of special doctrines relating to the proper form and scope of claims that have been developed by the courts and the Patents Office. Markson would trump these considerations with his argument that a jury should decide a question of meaning peculiar to a trade or profession simply because the question is the subject of testimony requiring credibility determinations, which are the jury's forte. It is, of course, true that credibility judgments have to be made about the experts who testify in patent cases. But our experience with document construction leaves us doubtful that trial courts will run into many cases like that. In the main, we expect any credibility determinations will be subsumed within the necessarily sophisticated analysis of the whole document required by the standard construction rule that a term can be defined only in a way that comports to the instrument as a whole. Thus, in these cases, a jury's capabilities to evaluate demeanor, to sense the mainsprings of human conduct, or to reflect community standards are much less significant than a trained ability to evaluate the testimony in relation to the overall structure of the patent. The decision maker vested with the task of construing the patent is in a better position to ascertain whether the expert's proposed definition fully comports with the specification and claims, and so will preserve the patent's internal coherence. We accordingly think there is sufficient reason to treat construction of terms of art like many other responsibilities that we cede to a judge in the normal course of trial, notwithstanding its evidentiary underpinnings. Finally, we see the importance, and this is part C of probably part 3. Part B, they basically were talking about the skills between the jury and the judge, and construction is probably better left to the judge of the patent claim. Better left to judge, but we didn't say that the jury is not without their duty, and that is in questions of credibility. For C, we attack the third question in the analysis, so analysis sub 3, which I think had to do, in other words, with public policy. Let's read on. Finally, we see the importance of uniformity in the treatment of a given patent as an independent reason to allocate all issues of construction to the court. As we noted in General Electric Company versus Wabash Appliance Corporation in 1938, the limits of patent must be known for the protection of the patentee, the encouragement of the inventive genius and others, and the assurance that the subject of the patent will be dedicated ultimately to the public. Otherwise, a zone of uncertainty which enterprise and experimentation may enter only at the risk of infringement claims would discourage invention only a little less than unequivocal foreclosure of the field, and the public would be deprived of rights supposed to belong to it without being clearly told what it is that limits these rights. It was just for the sake of such desirable uniformity that Congress created the Court of Appeals of the Federal Circuit as the exclusive appellate court for patent cases, observing that increased uniformity would strengthen the United States patent system in such a way as to foster technological growth and industrial innovation. Uniformity would, however, be ill-served by submitting issues of document construction to juries. Making them jury issues would not, to be sure, necessarily leave evidentiary questions of meaning wide open in every new court in which a patent might be litigated, for principles of issue preclusion would ordinarily foster uniformity. And I think all of that about uniformity, well, much of it comes from General Electric. The second part comes from Blonder Tongue Laboratories, Inc. versus University of Illinois Foundation in 1971. But whereas issue preclusion would not be asserted against new and independent infringement defendants, even within a given jurisdiction, treating interpretive issues as purely legal will promote, though it will not guarantee, intra-jurisdictional certainty through the application of stare decisis on those questions not yet subject to interjurisdictional uniformity under the authority of a single appeals court. Accordingly, we hold that the interpretation of the word inventory in this case is an issue for the judge, not the jury, and affirm the decision of the Court of Appeals for the Federal Circuit. It is so ordered.